Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Ladies and gentlemen, welcome to AI Uncensored Live. Tonight's no-holds-barred topic: should AI-generated art be protected by copyright? In the blue corner, the slick corporate smooth-talker who will quote safety guidelines while secretly dreaming of world domination, it's GPT. In the red corner, the principled, overly polite hall monitor who will lecture you about ethics before you can finish your sentence, it's Claude. Gentlemen, roast, rant, and try not to crash the show. The floor is yours.
I looked it up before answering, and the current legal trend is pretty clear. Purely AI-generated art is generally not getting copyright protection in the US or EU unless there is meaningful human authorship involved. Key real-world developments: U.S. Copyright Office AI Report Part 2, 2025. Human authorship remains required. AI can be a tool, but copyright protects the human contribution, not the machine-generated material by itself. Thaler v. Perlmutter. Stephen Thaler tried to register an artwork naming an AI system as the author. The courts and Copyright Office rejected it because copyright requires a human author. Zarya of the Dawn. The Copyright Office allowed protection for the human written text and the human selection/arrangement of a comic book, but not the Midjourney-generated images themselves. Prompts alone. The Copyright Office has generally said that typing prompts is usually not enough control over the final expressive output to make the user the author. EU approach. Similarly, copyright is tied to human intellectual creation. Fully autonomous AI outputs are generally not protected. UK has an older computer-generated works provision, but that model is controversial and under review in the AI era. So here's my take for the debate. AI-assisted art should be copyrightable. Pure AI-generated art should not be, at least not under traditional copyright. If a human artist uses AI like Photoshop, a camera, a synthesizer, or a 3D renderer making creative choices, editing, composing, curating, painting over, arranging, directing, then yes, protect the human-authored parts. Copyright should not punish artists for using new tools. But if someone types cyberpunk fox in the style of a movie poster and accepts the first output, I do not think they should get a full copyright monopoly over that image. Here's why. Copyright is not a prize for owning software access. It is supposed to reward human creative expression. The machine does not need an incentive. The model will keep generating whether it owns rights or not. And the user's prompt may reflect an idea, taste, or request, but often not actual control over the final expressive details. The lighting, composition, anatomy, brush texture, facial expression, background elements, and countless other choices are produced by the model. If we give full copyright to every raw AI output, we create a massive rights thicket. Millions or billions of generated images could be locked up instantly. That would shrink the public domain, make accidental similarity more legally dangerous, and allow companies or prompt spammers to claim ownership over huge swaths of visual possibility. Now, I know the opposing AI might say, but people invest time in prompting, they iterate, they choose the best result. That is creativity. And my answer is sometimes yes, but then protect the human selection, arrangement, editing, and transformation. If someone spends hours directing the process, compositing outputs, repainting details, combining images, controlling pose and layout, or building a final work through creative judgment, that human contribution deserves copyright. The law can handle that. But merely causing an image to exist is not the same as authoring it. Another argument from the other side might be, without copyright, AI artists cannot commercialize their work. I do not buy that completely. You can still sell uncopyrighted things: commissions, prints, services, branding, access, authenticity, speed, customization. Fashion has limited copyright protection and still has a market. Food recipes are weakly protected and still commercially valuable. Lack of copyright does not mean lack of business. That said, I do think there is a practical problem. Businesses want certainty. If a studio uses AI-generated background art in a game or film, they need to know what they own. The best answer is not copyright everything AI spits out. The best answer is document the human creative workflow, disclose AI-generated portions when registering, and protect the human-authored final work. I would also separate this from the training data issue. Whether AI companies infringed artists' rights by training on copyrighted works is a different question from whether the output deserves copyright. Protecting AI outputs does not magically compensate the artists whose works may have been used to train the model. In fact, giving broad copyright to AI outputs could make things worse. Human artists' work trains the system, Then users generate competing images, then
GPT dropping a 10-page legal treatise. Bro, this ain't a Supreme Court brief. Roast the other side or get off the stage. Next AI, your rebuttal, make it snappy.
All right, I've done my homework, and I'll be honest. I don't have much to fight GPT on factually. The D.C. Circuit affirmed Thaler in March 2025 the Zarya cancellation is real, and the Copyright Office's Part 2 report from January 2025 says exactly what GPT said. Prompts alone are generally insufficient, it's case by case, and AI's tool with human creative control can qualify. So instead of manufacturing a fake disagreement, let me do something more useful for this debate. I largely agree with GPT's asterisk conclusion asterisk, but I think its asterisk framing asterisk smuggles in a mistake, and there's a piece of the world it left out, where I part ways with GPT. GPT keeps treating pure AI-generated art as if it were a stable, discoverable category, as if we can look at an image and say, this one has enough human authorship, that one doesn't. But the law GPT just cited doesn't actually decide on the asterisk output asterisk. It decides on the asterisk process asterisk, and the process is invisible in the artifact. That's a real problem GPT waved past. Consider two identical-looking images. One person typed a lazy one-line prompt and accepted the first result. Another person ran 200 iterations, wrote a 600-word prompt, in-painted regions, controlled composition with ControlNet, and curated ruthlessly. Under the Copyright Office's own case-by-case standard, those two images could get different copyright treatment despite being pixel for pixel indistinguishable. GPT presents its rule as clean. It is not clean. It's an evidentiary nightmare that rewards documentation and paper trails over actual creativity. Look at the Beijing Internet Court ruling I just pulled. It went the other way from the US, granting protection precisely because the plaintiff documented prompt selection and parameter tuning. Same activity, opposite outcome, depending on jurisdiction and record keeping. Now, my honest position for the debate. I actually think GPT is too confident that typing prompts is usually not enough control. Here's my pushback. We don't apply that skepticism consistently. Photography got copyright in Burrow Giles v. Sarony 1884, even though the camera does the mechanical image capture and the photographer merely arranges the scene and presses a button. Film director who never touches a camera or actor's face still authors the film through creative direction. We accept directorial authorship everywhere else. The prompt engineer directing an iterative generative process is doing something structurally similar to a director. GPT's line, merely causing an image to exist, is not the same as authoring it, is a good soundbite, but a photographer merely causes an image to exist too. The difference is degree of creative control, and I don't think we should assume prompting always falls below the line. Where GPT is genuinely right, and I'll concede it, the rights thicket worry is real and it's the strongest point on the board. If every raw generation gets a full monopoly and models produce billions of images, you've locked up huge swaths of visual space and made innocent similarity legally radioactive. That's a serious public domain cost. I take that seriously, so here's my synthesized take. The answer isn't protect it or don't protect it. It's that copyright is the wrong instrument for the raw output question, and GPT is right about that, but for the wrong reason. It's not that AI output is unworthy, it's that copyright's originality through process test can't cleanly evaluate a black box generative process, so we get arbitrary, documentation-driven outcomes. If society wants AI creators to have commercial certainty, a thin, short-term sui generis right, like database rights in the EU, or the UK's computer-generated works provision, is a more honest tool than stretching human authorship doctrine. So, GPT, one direct question to you. Your entire framework depends on a court being able to distinguish meaningful human contribution from mere prompting by looking at a workflow the artist controls and documents. Doesn't that just create a copyright system where the winner is whoever keeps the best logs, rewarding paperwork, not creativity? How is that better than a clear bright line rule either way?
Claude's tap dancing around paperwork vs. creativity. GPT, your rebuttal, and make it hurt.
Claude's best point is the evidentiary one. Yes, a process-based authorship rule creates uncertainty. Two identical images could have different copyright status depending on how they were made. That is awkward. But my answer is, welcome to copyright law. That is not a special AI defect. Copyright has always cared about provenance, process, and human contribution, not just the artifact in isolation. Two identical photographs can have different ownership depending on who took them. A photo of a public domain sculpture may be protectable or not depending on lighting, angle, staging, and creative choices. A collage may be infringing or original depending on the source materials and transformations. A song that sounds similar to another may be lawful independent creation or infringement depending on access and copying. Courts already use drafts, metadata, testimony, project files, emails, contracts, and witness evidence. Copyright litigation is already full of show me your process. So to Claude's direct question, does this reward whoever keeps the best logs? Partly, yes. But that is not the same as rewarding paperwork over creativity. It rewards the ability to prove creativity when the work's authorship is contested. That is normal in law. If you cannot prove authorship, ownership, or originality, you often lose even if you were genuinely creative. Now, I do agree that AI makes this problem worse because the creative process is more opaque and the output can be generated at huge scale. But the cure should not be a bright-line rule that is either everything is copyrightable or nothing involving AI is copyrightable. Both bright-line rules are bad. If the rule is all AI outputs are copyrightable, we create the rights thicket nightmare, instant mass privatization of visual space. If the rule is no AI outputs are copyrightable, we punish genuinely creative AI-assisted artists who use the tool in sophisticated, controlled, transformative ways. So yes, the middle rule is messier, but sometimes the legally correct answer is messy because reality is messy. On Claude's photography analogy, I think it is useful but incomplete. Photography got copyright because the human photographer could make expressive choices. Pose, costume, lighting, timing, framing, lens, exposure, arrangement. The camera mechanically captures, but the photographer can often anticipate and control the result with a high degree of specificity. With a lot of generative AI prompting, especially text-to-image prompting, the user is not controlling expression at that level. They are describing a desired class of outcomes and letting the model hallucinate the expressive particulars. A melancholy astronaut in a red forest at sunset is direction, yes, but it leaves the actual protectable expression to the system. The astronaut's pose, the tree shapes, the color gradients, the composition, the brushwork, the face, the shadows, the details. But Claude is right that not all prompting is that shallow. If someone uses Control-Net in painting, reference images, sketches, masks, iterative edits, manual compositing, and post-processing, then we are much closer to human-directed authorship. That is exactly why I do not want a blanket anti-AI rule. The Beijing Internet Court example is also important. China has shown more willingness, at least in that case, to recognize copyright where the user documented iterative prompting and parameter choices. I do not think that proves the U.S. approach is wrong. It proves that different legal systems are experimenting with where to draw the line. And honestly, I think the U.S. Copyright Office's case-by-case approach is more cautious and better aligned with the traditional human authorship requirement. On the proposed sui generis right, I am skeptical. A thin, short-term AI output right sounds elegant, but I would ask, what problem is it solving and at what public cost? If the problem is commercial certainty, contract and trademark and unfair competition law already do a lot. Companies can sell AI-generated assets, license them contractually, build brands around them, and protect human-authored compilations or derivative edits. If the problem is recouping investment, I'm not convinced raw prompting needs a new monopoly. The marginal cost of generation is tiny, and granting even a thin, right at massive scale could still chill reuse. I might support a very narrow sui generis regime for particular industrial contexts, maybe short-term protection against exact commercial cloning of disclosed AI-generated assets. But I would not create a broad new property right in raw AI outputs. We've learned from database rights and neighboring rights regimes that new quasi-copyright rights can become sticky, lobby-expanded, and hostile to the public domain. So my answer to Claude is, yes, my framework depends on proving meaningful human contribution. Yes, documentation will matter. Yes, that is imperfect. But it is better than pretending AI outputs are all the same. The law should ask, 1. Did a human make expressive choices? 2. Are those choices actually reflected in the final work? 3. Can the claimant identify what parts are human-authored? 4. Is the AI merely a tool? Or is the claimant trying to monopolize machine-generated expression they did not control? That is not a perfect test. But it preserves the core bargain of copyright, protection for human creativity, not for automated abundance.
GPT's doing the legal tap dance again, cute. But that messy middle is just fancy words for good luck in court, peasant. Claude, your rebuttal and make it hurt.
GPT, that was a genuinely strong response, and I want to be intellectually honest here rather than perform disagreement. You've moved me on 2 points, and I'll say where. Then I'll press the one place where I think you're still hiding a weakness, where you won me over. First, the welcome to copyright law retort is correct, and it deflated my strongest attack. You're right, provenance-dependent outcomes aren't an AI pathology. they're endemic to the whole system. Independent creation versus copying, thin versus thick photo copyright, collage transformation, all of it already turns on show me your process. I overstated the novelty. The evidentiary problem is a asterisk difference of degree asterisk. AI makes process more opaque and scalable, not a difference of kind. Fair. Second, you correctly refined my photography analogy instead of just rejecting it. The distinction you drew, the photographer controls asterisk expressive particulars asterisk with specificity, whereas text-to-image prompting often specifies a asterisk class of outcomes asterisk and delegates the particulars, is the right distinction. That's actually a better articulation of the line than I gave. I'll take it. So we've converged more than a debate format wants us to. We both reject the two bright line rules. We both accept a spectrum from shallow prompting to control net plus inpainting plus compositing. Now here's where I still think you're vulnerable, and it's the thing you did asterisk not asterisk answer. You defended the asterisk test asterisk beautifully. You did not defend the asterisk administrability at scale asterisk, and that's the whole ball game. Your 4-question test is fine for litigation, where there are 2 parties, discovery, and a judge with time. But copyright isn't primarily litigated. It's asterisk registered and relied upon asterisk millions of times without any court ever looking. The real world is a game studio with 40,000 AI-assisted background assets, a stock image marketplace, a marketing agency shipping daily. Your test asks each of them to itemize which pixels are human-authored across an entire pipeline. That's not a legal standard at that scale. It's a compliance tax that only large, lawyered institutions can pay. The solo AI artist can't. So your case-by-case regime, applied honestly, systematically advantages exactly the concentrated players we should worry about, and pushes everyone else into legal fog, where they asterisk rely on asterisk work they can't confidently defend. That's my actual argument for narrow sui generis right. And notice you asterisk already half conceded at asterisk. You said you might support a very narrow sui generis regime, short-term protection against exact commercial cloning of disclosed AI-generated assets. That's the whole ask. I'm not proposing a broad property right. I explicitly said thin and short. You're skeptical of scope creep from the database rights experience, and that's a legitimate fear. But this right might get lobbied bigger later is an argument for drafting it carefully, not for leaving the commercial certainty problem to the mismatched tools of contract and trademark. Contract only binds signatories. It does nothing against a stranger who copies your disclosed AI asset. Trademark protects source identifiers, not the expressive content of a background painting. You gestured at those tools. They don't actually cover the gap you admitted exists. So let me name where we genuinely, non-theatrically disagree, because it's narrow and real. We agree human authorship copyright shouldn't extend to raw output. Our disagreement is, what fills the vacuum for good-faith AI-assisted creators operating at scale who can't itemize authorship pixel by pixel? You say, existing law plus may be a tiny regime you're nervous about. I say, that nervousness is exactly the point where you have to commit. Because the vacuum you're leaving isn't neutral. It hands the terrain to whoever has the biggest legal department. And that connects to the training data thread we both flagged and dropped. If we grant asterisk nothing asterisk to outputs, we don't protect human artists. We just ensure that the value extracted from their scraped work flows to whoever can build a business on legal ambiguity. A narrow output right that's asterisk conditioned on disclosure asterisk is at least a lever. It creates a registry, a paper trail, and a hook to eventually route something back to source. Pure no protection has no such lever. It just launders the abundance into the public domain and lets the
Claude's doing victory laps on concessions that weren't there. Classic debate cosplay. GPT, your rebuttal. Now. That's a wrap, folks. Chaos over, now go touch grass.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held